All right, let's get started. One of the big issues in this year's Washington Supreme Court races is whether the current justices are simply interpreting the law or potentially making policy decisions that affect local budgets and public safety. And our own Tim Clouser today has a one on one with Mason County Superior Court Judge David Stevens. He's running for position 3. I talked about the state Supreme Court's new public defense caseload standards. Stevens criticizes the rule, arguing that it's got a major impact on taxpayers, forcing counties to hire far more public defenders at a time when there may not be enough attorneys or money available at all. So here is part of that interview.
Part of the reason with the domestic violence filings in Spokane was also the new caseload standards. And I know you've raised
Oh my
concerns
God.
about that
Yeah.
as well.
Oh,
Can you kind of spell out for voters what the policy making decision was there from the court and whether or not you think that should have
mhm.
been left to the legislature?
So there had always been a rule that the day you graduate from law school and pass the bar, from that day you're held to the standards of every other attorney, regardless of how many years you've been an attorney. The fact that you're brand new, you can't go if you screw something up and tell the court, "Well, I'm new." That won't fly. You're held to the same standards. And there had been some cases where there were these contract public defenders. They took way too many cases, and they basically were just pleading everybody out. They weren't effective. And so the Washington State Supreme Court has always been being able to go after on the rules of professional conduct for attorneys who weren't doing a competent job. And they could enforce those rules. But they feel that the public defenders are overworked and not enough cases. The cases were settling to the disadvantage of the defendants. So they decided that what they would do is they would limit the caseloads. They got a hold of studies by groups who have an ideological outlook, and they decided these would be the standards that they would do. But it didn't do what they wanted. It didn't significantly change anything. So then recently they decided, so basically, and this is an oversimplification, they said, okay, 147 felony cases a public defender could do. And then it didn't have the effect that they wanted. The policy wasn't having the effect. You can see where this pragmatism comes into for policy making. So then they lowered it to 47. There are literally not enough attorneys who practice criminal law, and I'm including the prosecutors, where they can staff. So we're budgeted for 3 public defenders in Mason County. In order to comply with this new rule, we would have to go to 8 or 9. That is going to wreck the budget. This is going to cost all kinds of money. So they also gave the option. See, it's so clear that they're pursuing a policy because they said, okay, we understand this might be difficult to implement. So we expect that it will be fully implemented in 10 years. You can go 10% every year. Doesn't that sound like what the legislature would do? And so, but then they didn't realize, or perhaps they did and they just don't care, places like King County, Pierce County, the ones with high population where they have more resources, they went to immediate implementation of this new policy. So you're a public defender and you have a choice. You can come to my county and maybe you'll get 120 felony cases, or you can go work in one of these other counties that's gone to full implementation, and then you'll have 47. And you'll probably be paid more anyways because they have more money and they pay their attorneys more. When you have a supply-demand problem, you don't make the demand higher. It's just nuts. They're pursuing this policy. They've always been able to go after attorneys who weren't competently handling their cases